Welcome to Seize the Mains by Raj Malhotra's IAS Academy. I'm Surbhi Sardana and this is Season 3 of our Daily Answer Writing Initiative. This initiative runs in coordination with our website, which is rajisacademy.com. From Monday to Saturday at 9 p.m. we discuss model or sample questions for UPSC Civil Services Mains examination. All these questions are taken from current affairs, the issues that you read around in newspapers or important magazines for your civil services. These questions are framed around those topics, and the model answers, the sample answers, our team sits on an everyday basis and these answers are created, and this initiative is basically to help you guide with answer writing practice because not a lot of guidance is available in the market. Also, this is an entirely free of cost initiative. We just do not let you how to let you know how to go ahead with answer writing. We also have this comment section on our website. So this let's say we are discussing this question today, and what you can do is after watching the video you can write your own answer and post it on our website in the comment section, and our team will evaluate your responses in the next few hours or next few days and give back their feedback entirely free of cost. So that's how we proceed. The topic for today is Collegium system, since this has been in news regarding a recent appointment in the High Court, in one of the High Courts of country. So yes, one thing I would like to mention here, that whenever you are sitting for mains, you cannot directly criticize an organ of the government, or you cannot directly criticize one of the pillars of democracy, whether it's judiciary, executive or legislature. Some questions will ask you to take a stand, they will demand a stand from you, that's for sure, but you have to take a very balanced approach. You cannot just have some very formal vocabulary, very diplomatic kind of vocabulary for yourself. Practice answer writing with us on a daily basis to understand how to write answers, because criticism questions cannot be very directly dealt with, they have to be played safe with when it comes to certain things. See, Collegium system is something that has been criticized in newspapers from time to time, and yes, there are chances that UPSC might ask again a question with regards to Collegium system. So yes, let's see what the question is. Transparency is one of the key components of administration, but there have been some challenges to it during the appointment process of judges. Discuss. Answer in 150 words. So this is a very short question, but this is a discuss question, but still it is asking you to take a stand against the appointment processes of judges. So yes, we will talk about what are the problems there, but we will not be very critical of the executive or of the judiciary or of the collegium system as a whole, because as reiterated by Supreme Court, collegium system is the final system for appointment of judges until unless government designs a new system. So till the date collegium system is functioning, you cannot take a very abrupt stand. Be very careful in what you choose to write. So yes, obviously since the question is about appointment process of judges, that is it is directing us towards Collegium system of appointment of judges. So what is it? Let's talk about it. Also a polity answer, it is a polity answer, so definitely never forget talking about articles of the constitution, and for any other matter, if it is a polity question, just not just articles of constitution, but some sections of CRPC, IPC, the popular ones, or the representation of people's act, some sections of that, with regards to some questions, they become very important. So make sure that these sections are at least learnt by you before your mains. For prelims they might not hold a lot of importance, but for mains some sections should be remembered, and coming just from current affairs and important topics, and then just write them down in your answer. Do not explain them, but just give a brief mention of them. So let's write about collegium system. Let's start with an introduction. What is collegium system and how does it function? So judges of higher judiciary are appointed through the collegium system, because collegium system term has not been used in the question. So our first line is that higher judiciary appointments, they happen through the collegium system. So underline this. The procedure to appoint judges to the Supreme Court and High Courts is listed under Article 124, that is for Supreme Courts, and Article 217 respectively of country's constitution. So that is where you go. The collegium system of appointment of judges has come under criticism because of the challenges associated with the transparency of the system. So 150 words answer, we will not stretch our introduction too much, we have mentioned the sections. Now we'll move on to our body paragraph, and the following are the issues which have emerged recently in the Collegium system, specifically with regards to transparency. So the first one is, they talk about the first problem is of opacity. These appointments happen behind closed doors. The names of the names of people who might be appointed as judges, they are not disclosed until the final appointment takes place. So in India, the candidate's name is effectively made public after their selection by the Collegium. The selection process is behind closed doors, where the parties involved are the Collegium and the government through the Intelligence Bureau. This not only has transparency costs, but also the costs are asymmetrical. So just think about it, that people who are to be appointed as judges, their names are not disclosed. Yes, there can be other side also, that for secretive matters or to maintain utmost secrecy, but here we are taking a light or a soft stand against the Collegium system, or under the we are talking about transparency, how transparency is not maintained. So these are the points for now. Then, given that the government retains the power of formal appointment, the power of formal appointment lays with the government. When it approves a candidate, it can rush the process through. Now be very careful, rushing the process has been seen recently in one of the cases. So in other cases, the government can exercise a pocket veto. So this was not known in the public domain. Recently there was an editorial in the Hindu which enlighten us about this, the UPSC aspirants, that they can exercise a pocket veto by refusing to appoint a judge in the teeth of an express discretion or direction by the Collegium. Then once a Collegium recommendation has been made, the only way of contesting that selection or that appointment is through a legal challenge, and that legal challenge, it goes to the court, it goes to the Supreme Court. So basically, who is sitting in your Collegium? In Collegium, your senior most judges are sitting and your Chief Justice of India is sitting. So when this appointment is contested in the Supreme Court itself, so there are chances that judges of these senior most judges, junior judges of these judges who were sitting in the Collegium, they will be deciding on whether the senior most judges or the people who were sitting in the Collegium, they have taken the right decision or not. So that is a very asymmetric cost that comes up, and it is very hard to differentiate between the boundaries. Also, it is not a very foolproof approach. However, that challenge must be before the Supreme Court itself, leading to a situation, the decision of Collegium, the 3 or 5 senior most judges of Supreme Court must be challenged before their own junior colleagues. So it is their junior colleagues who will be deciding whether their decision was right or not, and these colleagues will be assigned the case by the Chief Justice of India, who is himself the head of Collegium. So that is a feedback loop basically going on. It is a loop, it is a cycle. So how do we ensure transparency there? So do not write about anything outrightly, just mention it as a case there, mention it as a problem there, that this is the situation. Since appointments body, the Collegium, the body for constitution of benches, and the judicial review body, that is the Supreme Court. The appointment is happening through the judges of Supreme Court who are sitting in the Collegium. Then the body for constitution of benches, that is the Chief Justice Office, and the review body where your legal challenge goes, that is again the Supreme Court, are all effectively one and the same. They are the same authority. So how can you actually decide, or how can you guarantee that if there is some legal challenge occurring after appointment of a judge through the Collegium system, then the final decision would be a fair decision? So trying to play different and functionally independent roles, correction becomes very difficult. So correction in a selection that has happened through the Collegium system, that becomes very difficult, and that is a very good point there. In an example coming from the Supreme Court of South Africa, this court, the review court and the Supreme Court, they are separate entities. So yes, it was also mentioned that it is not necessary that that functions in a very perfect manner, but something of that sort has to be brought in the country to ensure utmost transparency. And the fifth problem is that your appointments to higher judiciary, there is a short list of people who can actually see themselves being appointed at positions in higher judiciary, and these are the people who have served at senior legal positions. They have been advocates in the High Court, or they have held positions like Solicitor General or any Advocate General, or like high positions as advocates, or So whenever there are appointments happening through the Collegium system does not have a very vast list. It has to choose from a very short list of people, and these people in turn, they are actually appointed by government, all these posts. Let's see. The majority of High Court judges are appointed from the pool of lawyers who practice in the High Courts or Supreme Court. These are mostly the persons who have served as Additional Solicitor General, appointed by government, Advocate General, again appointed by government, Additional Advocate General, or members of the Standing Council of Central and State Governments. So these are the people who who have a chance to be selected as judges in higher judiciary, to be recommended or to be selected by the Collegium system. And these people, this list, how are these people entering the list? They are entering through government appointments or through the support of government. So at the end of the day, it's government who is making the decisions. So appointments to these positions are made by governments rather than the judiciary, which means that the governments are indirectly responsible for upgrading the profile of advocates, which then increases their chances of being recommended by the Collegium for appointment as judges. So that is where your problem is coming, the separation between various organs, various pillars of democracy, executive, legislature and judiciary, and there is the system of checks and balances between the decisions of Collegium system and the review court, or where the legal challenge is occurring. That is both lying in the Supreme Court, and a lot of power to choose the benches or to choose people at the benches, that is in hands of Chief Justice of India. So we need to ensure some kind of separation there, since this issue has come to the limelight. More effort needs to be given towards research in this matter and to bring in amendments. So yes, again, this was a new question taking a new stand on the Collegium system and what are its drawbacks, what is the downside of it, what are the problems associated with it. In your conclusion, just reiterate the statement of Supreme Court that this is the system that is functioning for appointment of judges unless there is a new system that is devised by central government. And as reiterated by Supreme Court, until government brings new law on judicial appointments, Collegium system is the law. So yes, a law was brought by the central government. It was called National NJAC, the NJAC Act, that was brought in by the government, but that was struck down by the Supreme Court as unconstitutional. So that is also something that should stay in your mind, but definitely quote this as a direct statement. Do not bring the issue of NJAC and that Collegium system is the way to go for now. Do not bring them at the same time. It is important to locate the roots of the problem in the structure of our judicial appointment process. This is a very important line there, again from the same editorial. A system of checks and balances needs to be strengthened, at the heart of which are the values of transparency and publicity. So yes, that's your full answer for the day for Seize the Mains day 187. Visit our website, which is rajayasacademy.com. Look for question 187. When you click on the link in the description, it will take you to this website. Click on the mains answer writing section, and here not just question 187 with its answer, the previous 186 questions with their full-fledged sample answers, all taken from current affairs, would appear, and you can send your answers to us on any of them and post your comments in the post your answers in the comment section, and our team evaluates those responses on a regular basis free of cost. So yes, stay tuned to the channel. I'll see you with another discussion tomorrow of Seize the Mains at 9 p.m. Till then, keep working hard and all the best.